Hello, I'm Amanda Moore. I'm the Director of the Clearinghouse Community. Welcome to the Advocacy Exchange for November 2017. The Advocacy Exchange is our monthly conversation with advocates advancing change. Now, both the Advocacy Exchange and the Clearinghouse Community are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. I am joined today by Greg Bass. Greg is a senior attorney at the National Center for Law and Economic Justice, and he's joining us today from New York City. Hello, Greg. Thanks for being here.
Good afternoon, Amanda. How are you?
Doing just fine. So Greg wrote one of our recent advocacy stories on the Clearinghouse. It's called Litigating the Right of Clients with Visual Impairments to Access Public Benefits Documents in Alternate Formats. You can find that advocacy story at the address here on my screen, povertylaw.org/clearinghouse. The advocacy story describes the Rafferty v. Dorr case, which was a federal class action under the Americans with Disabilities Act. The National Center for Law and Economic Justice filed that in New York on behalf of clients with visual impairments. And we're going to talk about that case in greater detail in today's episode. But first, I want to tell you how you can be part of this conversation. I know most of you are watching this through YouTube Live, and if you'll notice on the right side of your screen, or if you're on a mobile device at the bottom of your screen, there's a live chat option. And we would love to hear from you that way. You can go ahead and try it out now if you'd like. You could just send us your name and where you're watching. We'd love to hear from you. And as we progress through this conversation, if you have questions or relevant experience that you'd like to share, we would love to hear that and invite you to join in. If live chat isn't your thing, that's okay. You can also email me. My address is on the screen. It's Amanda Moore, M-O-O-R-E, at povertylaw.org. And I'll be keeping an eye on that too, to look out for your questions that I can pass along to Greg. Everyone who registered for today's broadcast will get an email in the next few days. It will contain a link to a recording of today's conversation, Greg's advocacy story, as well as a link to register for next month's Advocacy Exchange. So keep an eye out for that email. So now let's turn to Rafferty v. Dorr. Greg, could you tell us a little bit about the situation that led you to file the Rafferty case?
Well, Carrie Lachine, who is a noted disability rights advocate who used to work at NCLEJ a number of years ago, she started reviewing cases that were brought in the private sector on behalf of individuals who were blind. Everything from websites, from H&R Block to Amazon, to talking prescription labels from pharmacies, to talking ATMs. This was all under Title III of the ADA, which basically is the private accommodation, private sector title. And she thought that that needs to translate into the public sector, most notably public benefits agencies that our clients resort to for critical subsistence benefits. And there wasn't any real litigation in that sector, apart from a case in California that was a landmark case brought against the Social Security Administration under the Rehabilitation Act that ended up getting their documents, their notices, their forms into alternate formats that individuals who are blind or seriously visually impaired could actually access. So we started reaching out to various groups here in New York. As it happens, we're just a couple of blocks away from the New York affiliate of the National Federation of the Blind. They have their meetings in a building just close to our office. And we attended meetings and started talking with members of NFB and asked them what their dealings were with the public benefits agencies here in New York City, if they had any luck in getting documents in alternate formats that they could read, like Braille or large font or data format or audio format. And there was nothing of that kind. So we started to reach out to the Human Resources Administration, which is the New York City benefits agency, and the Office of Temporary and Disability Assistance, which is the New York State agency. And we asked them if they would be willing to put a database together of existing forms, like applications, into alternate formats. They basically said no. So we started working with individual clients who were having experiences where they were told, all that we will afford you is the opportunity to come to a welfare office and have somebody read forms to you. And we reasoned that that wasn't enough. That wasn't what the ADA required. And we started to put together the Rafferty litigation.
So what was it that your clients wanted to get out of this? What was the, you went to community meetings. What were you hearing that people would like to have?
Access and individual dignity. These clients have not typically come into a legal services office over the years. They've made do. They've fallen in between the cracks. They get these critical documents in the mail typically, or handed to them in person, and they obviously can't read them. And this is everything from an individual who's visually impaired and they require large font to somebody who's literate in Braille. They will have a friend or a relative or sometimes a complete stranger read forms to them and help them through the process of answering those forms, like food stamp recertifications, and they make do. This has happened for years and years and years. So what they wanted more than anything was individual dignity. They wanted not to have to share confidential, sensitive, private information on these documents that involve their welfare benefits to complete strangers. They wanted to be able to do these things on their own, like anybody else would do. And they also wanted the assistance of the city and state agencies where necessary to talk with them and get them through the process. And that's the ongoing reasonable accommodation obligation that the agency already has. So these folks were looking for independent access and dignity.
So what was your strategy to get there? How did you approach this case?
Well, we started working with individual clients who were on Medicaid and food stamps, and they needed their documents into some sort of alternate format, and they weren't getting them. So we would assist them in trying to request alternate format accommodations. They would be denied by the city agency, and then we asked them if they would want to be named plaintiffs, if they would want to represent a class of similarly situated individuals. And we found a group of individuals who were more than willing to do that. They were outraged that this was something that had never been afforded to them as their right under the ADA. They were, for the most part, very conversant with their rights under the ADA. And they told us stories such as having to go to welfare waiting room offices, waiting for somebody to call their name. And then the staff person would say, right this way, follow me. And this individual literally couldn't see where they were being directed to go. It was that level of insensitivity that they were outraged at. And they knew the importance of these documents that they were getting on a regular basis to maintain their subsistence benefits, so they needed a way to access them. So we put together the Rafferty versus Dorr case. We reasoned it was a class action because there were thousands of individuals in New York City alone who are blind and who are receiving assistance in the form of SNAP benefits or Medicaid benefits. And we put that class together and filed suit in March of 2013.
And so what was the outcome? How did it go?
The case progressed for about 2 years in essentially a negotiation posture. To their credit, the city and state agencies that we sued, the Office of Temporary and Disability Assistance, which is the New York State agency. New York is a bifurcated state county system. And we sued the Human Resources Administration in New York City. We also sued the State Department of Health. So we covered a class of individuals who are getting or applying for either SNAP or Medicaid benefits and who were blind or seriously visually impaired in a defined way under the ADA. To their credit, they did not really fight the case on the merits, with one exception. They said that we don't want to do Braille for two basic reasons that were mutually contradictory. They said not many people are literate in Braille anymore, so we don't think it makes that much difference. And even if it does, it's too expensive to translate documents into Braille, to transcribe them. So we said Braille is definitely part of this lawsuit. We're not going to take it off the table. If you care to make your best pitch legally to the court, we'll go back to the court and have the judge address that issue. But keep in mind that the Department of Justice regulations expressly reference Braille. Soon after that, Braille was put back on the negotiating table. And like I said, the process took a little over 2 years to negotiate. The main problems were that this sort of system had never existed before in New York. And for the most part, it hasn't existed in any state in the country. Every state has an agency that is probably susceptible to a Rafferty versus Dorr lawsuit. And I know we'll talk about that in a minute. What they needed to do were two basic things. They needed to put together a database of existing forms like applications, informational brochures and leaflets, client outreach materials, and convert those into alternate formats. We wanted Braille, large font, data format, which is, for example, a format that can be read by an assistive screen reading device, and also audio format. They had to develop a database of their existing documents to do that, but more fundamentally, they had to commit to a system of getting individual client household notices to people who are blind or visually impaired on time and in an essential, streamlined fashion. So every time somebody who is blind gets a notice affecting their benefits, like a recertification notice for SNAP, if they've already told the agency that they are blind and they need their notices in Braille, for example, that has to happen. The agencies thought initially that they could do all of this in-house, but keep in mind that we're talking about millions upon millions of individual client notices per year. They eventually discovered that it was too big a task, and so they contracted it out. It went through a fairly lengthy request for proposal, RFP, contract procurement process in New York City. And they eventually selected a vendor who could handle the task. And that got us to the point where we could negotiate a settlement agreement, putting their obligations into writing. And the court eventually approved it on a class action basis in October of 2015. The core obligations of the settlement clicked in for the most part on July 1st, 2016, so about a year and a half ago. And those core obligations of the settlement are basically just what I described, what took so long to negotiate. They have created a database of existing forms like applications in these 4 alternate formats. To my knowledge, no other state public benefit agency has anything comparable. But again, more importantly, what they've agreed to do is issue notices to individual clients and households when requested in the specified alternate format. And those are the core requirements of the settlement.
Got it. So you said it's been in effect now for almost a year and a half. So what kind of impact have you seen thus far?
It's been a pretty good impact. The class was certified specifically on behalf of New York City residents who are receiving SNAP or Medicaid and who are blind or seriously visually impaired. Since then, the state has agreed to expand the reach of the class action settlement statewide. So every social services district in every county of New York State essentially has to follow the Rafferty versus Dorr settlement. And the settlement was also expanded to include public assistance, TANF, basically cash assistance, and home energy assistance, the Home Energy Assistance Program, or HEAP. So the settlement has greatly expanded beyond New York City. Part of what we get as plaintiffs' counsel is quarterly statistical reporting. And the most recent stats, these were just recently updated, so they're even more than this. But as of July of this year, about 2,500 SNAP recipients just in New York City have requested and received documents in alternate formats. About 2,300 Medicaid recipients have gotten documents in alternate formats as well. And the settlement also covers the fair hearing system. So any fair hearing related document that you want converted into an alternate format, that has to happen as well. And as of July of this year, about 500 clients requested and received alternate format fair hearing documents. So the impact has been pretty good. And again, bear in mind that these are just New York City statistics and numbers. The settlement, since it applies statewide now, we have every reason to suspect that the numbers are larger. Smaller rural counties obviously aren't going to see these sorts of numbers, but there will be an impact throughout the state.
Will you get those numbers? Like you're getting the ones for the city?
Not in the way we get them through the Rafferty settlement. Part of what I do in my job is to do collaborative work with county departments of social services throughout upstate New York. We help them draft an ADA compliance policy for their benefits clients. And then once that's finalized, we go out and train all of their staff. I'll be going out, for example, to Rockland County in a couple of weeks to train all 200 of their staff on their new ADA policy, which we drafted with them. And part of my pitch to them is to talk about the Rafferty case. Part of the Rafferty settlement requires that social services districts throughout the state receive training on what the Rafferty settlement requires and what the ADA generally requires for effective communication requirements for individuals who are blind or visually impaired. So I include that as part of my training to these folks. I supplement the training that they've already gone through, and I talk to them about what their experiences are with clients who are blind coming in through their waiting lobbies.
Got it. So I want to remind our viewers that we would welcome your questions that you have for Greg. You can send them either through the live chat on YouTube, or you can email me at the address on the screen, Amanda Moore, Moore, at povertylaw.org. And we had a question come in from Sarah in Boston. She sent us this earlier in the week, and I wanted to make sure that we got to it. It's a really good question. So Sarah asks, we have the experience that providing some auxiliary aids takes longer, and we're pushing our agency to move deadlines accordingly because of the additional steps that need to be taken, or because some resources, she gives us an example, finding ASL interpreters, can take longer. Is this something you dealt with in Rafferty? If so, were you able to work out the provision of auxiliary aids so that clients who needed them were given them in such a way that they had the same amount of notice as clients who did not need those auxiliary aids? If so, how did you pull that off? And if not, were they able to get the agency to adjust the deadlines accordingly?
It's a great point. Anytime that you're negotiating or trying to enforce reasonable accommodations for individuals who are blind or otherwise disabled under the ADA, they have to have sufficient time to comply with whatever eligibility requirement deadlines that they're facing. We did not specifically put that into the Rafferty settlement, in part because there was an existing policy of the Office of Temporary and Disability Assistance for all of New York State that dates back to 2006. And I'll just read a part of it. When an appointment is rescheduled for a person with a disability because reasonable accommodations cannot be made or no interpreter is available on the date the application is filed, the delay does not affect the application filing date or other dates relevant to the processing of applications. They assured us that that would apply in the Rafferty context as well, and it certainly would. As a matter of compliance with the ADA generally, it's not a reasonable accommodation if access is thwarted because you only have a limited time to perfect your rights, to comply with the eligibility requirements that you're facing. If your deadline is considerably shortened because they're converting the document for you into alternate format, that's not equal access, and that's not a reasonable accommodation.
Thank you. So you hinted at this earlier, but I'd really like to tease this out some. The strategies that you used in Rafferty, are those transferable to other situations that some of our viewers across the country may be facing with their own clients or their own state agencies?
It is. When I've talked to advocates around the country about ADA advocacy in general or ADA litigation, I make a couple of takeaway points. One is that the ADA is literally the best way sometimes to get into the courthouse, especially the federal courthouse. Many of the legal handles that we've been using for a long time, entitlement program handles, through the supremacy clause of the Constitution or other sorts of statutory mandates, due process constitutional handles, those have become increasingly difficult, as we all know, to use over the years, largely through Supreme Court jurisprudence and other circuit court and district court cases. So the ADA is often a way to attack dysfunction of public benefits agencies in particular, in a way that not only benefits individuals with disability and improves their access, but often improves access for people across the board. So that's one basic takeaway point that I try to offer folks. Another, if you're considering ADA advocacy, consider something like the Rafferty versus Dorr approach. It can often be fairly daunting to try to file an omnibus ADA compliance lawsuit against a public benefits agency in your state because they don't have procedures in place to adequately comply with the ADA. They don't have ADA coordination or grievance systems, much less any sort of system to track or give reasonable accommodations. So you're faced with an agency that across the board just doesn't systemically comply with the ADA. And I've been involved in those cases over the years in several states, and we're currently working on one as well. But sometimes you can think about a different approach, and that's the Rafferty approach. That's something more streamlined to get yourself into court and to get the agency more particularly into court in terms of compliance. Think about representing individuals who are blind or visually impaired, or a corollary lawsuit for individuals who are deaf or hard of hearing, and get their effective communication rights under the ADA before the court. And that can often open up their compliance avenues for those individuals in particular, and also for individuals with other sorts of disabilities. You'll often discover that there aren't any real access portals. There's no coordination, like I said, no grievances, no reasonable accommodations being tracked or given. And this might be a way to open up their compliance. This lawsuit is definitely capable of being replicated around the country. And like I said, it was the first of its kind in the country in the sense of using Title II of the ADA, which is the public entity title, to use that compliance framework against a state welfare agency and a city welfare agency. It can be done in virtually every state, and the policies that I've seen around the country, sometimes there is a good written policy that mandates effective communication, but it's not implemented, or else it may have conditions. In New York, for example, they had an effective communication mandate in writing for many years, but they said it's only to be implemented by the social services district when feasible. That's not what the ADA requires.
Right. We've had a question come in from Michelle in Baltimore, and she asks, when someone requests an alternate format of communication from their agency, does the agency require some kind of documentation to show they need the accommodation or have a disability?
That's a great question. The answer is absolutely not. The procedure that was built into the Rafferty settlement is a very simple, streamlined procedure, and it's designed to be used by clients on their own without having to consult an attorney. All that's required is a simple request. I'm blind or I'm seriously visually impaired and I need a document in an alternate format, Braille, large font, data format, or audio format. They don't have to supply verification that they're in fact blind or seriously visually impaired. There cannot be those sorts of large verification hurdles placed in their way by an eligibility worker. They can't be second guessed. Well, maybe the worker doesn't really think that they're blind. None of that applies. It's a simple request, and that's all. It doesn't have to be in writing. It can be oral. The eligibility worker is then directed either way to document it in the case file. And the settlement sets up a disability accommodation indicator, which is basically a tracking mechanism, so that every time a client's case appears on a worker's terminal, it will record that that person is blind or visually impaired and that they've requested an alternate format and what the format is. So the client doesn't have to reinvent the wheel every time they get something in the mail. They should get their documents, including individual notices, in their preferred requested alternate format.
So that brings up a question, Greg, about, anytime you have any sort of system-wide change like this, these days there's going to be a technical element of that. How were you involved in the technical aspect of this, having the thing pop up on the caseworker screen that says this person has requested this accommodation? Do you have to be intimately involved in that, or does the state handle it and just come to you for a check? How does that work?
The disability accommodation indicator was basically their show. They implemented it, and we followed and tracked how it was being implemented. And the success of it seems to be borne out by the statistics we're getting of people who've made requests, and those requests are being fulfilled on a regular basis. Literally, as I said, thousands of folks in New York City alone. Other aspects of the case, we had to be certainly cognizant of the technology for folks who are blind or visually impaired, especially in the terms of auxiliary aids that they can use and that they're entitled to use under the ADA, such as screen readers that can detect text off of internet websites, for example, or text off the written page and convert it into audio. That technology is changing on virtually a daily basis. And it's a cottage industry in itself, and thankfully so. So we had to be aware of the basic technology upgrades and try to incorporate those into our negotiations with the defendant.
So I know that the National Center for Law and Economic Justice is always interested in partnering with advocates around the country on cases like Rafferty. If any of our viewers have an experience like this that's going on and they want to get in touch with you, what should they do? Should they just reach out to you? Do you have a system that people should go through? What do you recommend?
No real system. Just get in touch with us by email, by phone call. You've got my email information on the screen. You can reach us easily. The article in connection with this Advocacy Exchange has our contact information. It's what we do. We work in tandem with legal services programs across the country. We work with public law firms, other public interest advocacy organizations. We have a whole network of partners that we've been able to assemble throughout the country over the years. And so we're prepared to serve in any sort of role that makes sense for folks out there, whether it's a sounding board, an advisor, co-counsel in a class action lawsuit, whatever the advocacy project needs. If we can help fulfill a role for you to help you, that's what we do.
That's wonderful. Thanks. And so Greg's email address is bass, B-A-S-S, at nclej.org. And as he said, that's available in his advocacy story that is published on the Clearinghouse community. You can find that at povertylaw.org/clearinghouse. Greg, I want to thank you for being with us today.
Thank you.
And before you go, I want to remind everyone that Greg's advocacy story is called Litigating the Right of Clients with Visual Impairments to Access Public Benefits Documents in Alternate Formats. As I said, it's at povertylaw.org/clearinghouse. If you found today's conversation interesting, the advocacy story interesting, please sign up for our mailing list. It's at connect.povertylaw.org/clearinghouse. That way you'll be sure to be notified of these events and future publications. And you can also subscribe to the Advocacy Exchange podcast. You no longer have to be tethered to a screen. You can find that on iTunes or wherever you subscribe to your podcasts. And I'd also like to invite you to join us for next month's Advocacy Exchange. Next month will be our annual Supreme Court recap when we talk about the cases from the last term that will affect our clients' ability to access the federal court system, which Greg referenced today is often seeming to get narrower and narrower. So we'll look at what the court said last term about federal court access. I'll be joined by Mona Tawatau of the Western Center on Law and Poverty, Jane Perkins of the National Health Law Program, Gary Smith of Legal Services of Northern California. That conversation will take place on Thursday, December 14th, same time as today, 1 o'clock Eastern and 10 o'clock Pacific. And we hope that you will join us next month for that. And until then, remember that you're not alone out there. Thank you.